And the basic motive was to expedite the recovery process in this financial sector. And there how we had on the paper with us this Recovery of Debts Due to Banks and Financial Institutions Act 1993, which is commonly known as DRT Act. This object was to fast track this loan recovery process. But again, there were certain problems. The legal validity of this act was challenged. We have, because today I don't have that PPT, otherwise I could have given you the citations and all in this. No. It was Delhi High Court Bar Association versus Union of India. Murder Chemicals came later.
Because with respect to securitization.
Yeah, because we are just
1994.
Yes,
that was 19.
Yeah, the citation I have, it is AIR. Yes.
I was the first person who implemented this act, 15 of March 1994 in Calcutta. First DRT presiding officer was Anand.
Yeah, very good. It's our pleasure to have the person who actually enforced the laws. There is no point in dealing in the history then.
You are there, speaker, we must respect.
So because there were certain it was pleaded that there is something which is unconstitutional, and later on it was upheld. And now we come on to, because then this legislation ultimately happened, and the preamble of this act stated, for expeditious adjudication and recovery of debts due to banks and financial institutions and for matters connected therewith or incidental thereto. But what happens, whatever is conceived by the legislature and whatever actually comes in the books, because that are very objective. We had this section 34 also. Section 34 provided this overriding effect to this act, and it said save as provided. I'll just read through this section 34, that subsection 2 of this particular act section shall have effect notwithstanding anything inconsistent therewith. But still nothing happened, and after that this debt recovery tribunals, they were also established. All of us are aware, debt recovery tribunal, we have that presiding officer, we have recovery officer, we have then DRATs were established if there was appeal to be filed, and there it was presided by the chairperson, we call it. And this jurisdiction of this was the powers of DRTs are limited to the cases which fall under its jurisdiction, and there were 2 points. The tribunal can take up the application from banks and financial institutions only, and that the application should be for recovery of debts. Again, this act was enacted, lots of cases were referred to this DRT, but the true purpose of the act could never be achieved. There were so many problems, and this act completely failed to convert recovery certificates, what we call as money, into real terms. Even though you could get awards, but again the execution of that, so those problems were there. Yes. After that, we have the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, which happened, which again it became a tool in the hands of the banks. Earlier, for any enforcement, banks will have to go to the court to take any action. But after this act was enforced, then this direct power was given in the hands of the bank, and they could enforce their security interest. This was basically because this ever-growing number of NPAs, this prompted this passing of RDBI Act, and this again special debt recovery tribunals were set up for recovery of NPAs. I'll just briefly discuss the salient features of this act. Securitization, basically the definition says, is the process of pooling and repaying of homogeneous illiquid financial assets into marketable securities that can be sold to investors. The asset may be anything ranging from credit card, receivables, auto loans, equipment leases, hire purchase deals to housing loans and NPAs. Securitization has emerged as important means of financing in recent terms. The process of securitization involves following steps. I'll just take up all these steps. We have 3 steps broadly. Firstly, an entity with loans or other income producing assets, which we call as originator, identifies the assets that it wants to remove from its balance sheets. Then we have the second process, special legal entity or SPV, we call it special purpose vehicle, which is created, which is usually established as a trust, and the originator sells the assets to this SPV. This effectively separates the risk related to the original entity's operations from the risk associated with collection. Thirdly, to raise funds to purchase these assets, the SPV issues asset-backed securities, Asset-backed security, I'll just explain, it is a security whose value and income payments are derived from and collected or backed by a specific pool of underlying assets which we call as illiquid assets to investors in the capital market in a private placement or pursuant to a public offering. And finally, investors are paid through the money received in the form of loan repayments by those borrowing loans through the originator. Originators are in turn paid certain services which are charged by SPV for the servicing of the loan. This process leads to the financial asset being taken off the balance sheet of the originator, thereby relieving pressures of capital adequacy and provides immediate liquidity to the originator. Meanwhile, because before I started, I just forgot, which your Lordship had pointed out, that we had to discuss that Murdia chemicals. There happened Murdia chemicals where again this constitutional validity was challenged. There were many important cases, but this SARFAESI Act and this judiciary, I'll just take up the arguments which were raised that this Act 1, it was not necessary as this Act, the DRT Act, which earlier I took up, already deals with the laws concerning recovery of debts due to banks, and that this Act did not provide adequate and efficacious mechanism of addressing the objections that the borrower has against the demand notice, and then that requirement of appeal that you'll have to deposit 75% of the claim raised in the notice is deposited. It was pleaded that it is violative of Article 14 of the Constitution. Also, it was said that certain provisions of the Act, such as classification of a particular asset as an NPA, it depended upon the whims and fancies of the financial institutions because there were no parameters to guide, and hence against the principles of natural justice. So these many things were pleaded. Other than then the court had observed in this Murdia chemicals case, which was AIR 2004 Supreme Court's judgment. So there it was said, it is to be noted that things in the concerned spheres are desired to move faster. In the present day global economy, it may be difficult to stick to old and conventional methods of financing and recovery of dues. Hence, in our view, the Supreme Court says it cannot be said that a step taken towards securitization of debts and to evolve means for faster recovery of the NPAs was not called for, or that it was superimposition of undesired law, since one legislation was already operating in the field, namely that what we call as DRT Act. So, the court had further held that the NPA problem is an important issue, retarding the growth of economy in general and financial sector in particular. And the fact that the NPAs have reached an alarming proportion was noted by several committees and institutions dealing in the financial sector. Against this backdrop of rich literature, because court had pointed out so many things, the court rejected this contention that there was no rationale for the enactment of specific legislation to address the concerns of growing NPAs in the bank. The court also pointed out that whether to draft a particular legislation or not is a matter of legislative policy, and such a policy decision cannot be faulted with, nor it is a matter to go to the courts for testing its legitimacy. Then there is one more important case which today I wanted to take up. This case was Transcode versus Union of India and transfer of, it was again 2009 banking cases, and the Supreme Court has again talked about the objectives of the Securitization Act. The court has said that the NPA removes the fetters which were in existence on the rights of secured creditors. The NPA Act is inspired by the provisions of the State Financial Corporations Act, in particular to section 29 and 31 of the State Financial Corporations Act. The NPA Act we again call this Securitization Act is known as NPA Act, proceeds on the basis that the liability of the borrower to repay has crystallized, that the debt has become due, and that on account of delay, the account of the borrower has become substandard and non-performing. So the objects of DRT Act and NPA Act is a recovery of debt by non-adjudicatory processes. So here in this case, the court has actually said that both this DRT Act and this your Transcode, they can have this parallel kind of proceedings can go on, and both the acts on their own. When we had brought this DRT, the DRT was also fine, and when because of the urgency or because of the situation, keeping track with the development and the rise in these NPAs, we had to come out with the Securitization Act. And there is no inconsistencies between the remedies which are available under the first one and the second one. So there is what you call as doctrine of election. that the victim will have to, means the bank will have to choose either of these. Either you go to DRT or you go to SARFAESI, to both of them. So you can correct me if.
We will give you 20 minutes later on.
Okay.
And that's giving the history how it has
Certainly,
come
sir,
about.
we'll have it.
And why it is going.
We'll have it.
I can tell you transport, I can tell you Haria chemical, I can go to Jasgir 4 and others. Now I can see. Red Carto, I can tell you.
Okay.
Only 2-3 minutes I can.
Yeah, I'll
have it,
just
sir.
try.
We'll have it.
Yeah.
We'll have
Yeah. Again, because of the paucity of time and because we have other.
Take my time.
Yeah. No, I.
For the knowledge of the audience, I was
Sir, I'll just. Okay.
one of the members of the team of Kapil Sibal who appeared before Supreme Court in Baradia's case.
Okay.
I was one of them.
Okay, that's very great. So that's why I was saying that when the chair told me to present it in the in the beginning of the session, I was really.
As he said, you are appropriate person. You have initiated the discussion. We'll have.
Okay.
Very crisp it.
Yeah, that's what. Yeah, so that actually the audience can get this. Yeah. Now I'll just like to wind up with whatever I have discussed. I'll not go into much detail because there are.
Will you give me the opening now? I will just, then you can open it because I will start from somewhere in the money.
Yes, sir. Yes, sir. I'll just finish. Sir, just give me.
Let her finish first.
Yeah, sir, I am just winding up. I'll just take one more minute. I have just few suggestions only that this SARFAESI Act should be properly implemented to clear certain complexities, and those complexities like priorities claims of government provided in certain taxation laws that defeat the recovery efforts of the banks normally, and that the tribunal should be strictly directed to adhere to the time frame. There is a time frame for the disposal of disputes under SARFAESI Act and it is usually overstepped. And another suggestion is inserting appropriate provisions in the Act for payment of actual cost can restrict frivolous litigation. So this is all what I have to say regarding the laws which are prevalent here, and now it is for the fair. I am very thankful.
Thank you very much, Dr.
I am
Jyotika.
very.
She has very briefly and nicely, she has covered the development of recovery acts and laws as far as bank recovery is concerned. There are so many eminent speakers on this topic because it's a burning issue nowadays for the entire country. More than around 70,000 crores of rupees are now sunk in NPAs, and recovery for banks is always has been a very, very big issue because unless and until you get back, how are you going to give to the people? So recovery has to be there. If it doesn't come, a day will come when only takers will be there, there will be no giving, nobody will give back. So it will be just empty bucket. So it has to come, and it's a very, very burning and good topic. So many speakers are there, and I think before opening it in the session, I would like next speaker to come so that once they are over, we can have an open session and we can discuss it. So,
Next is, what's the name?
Sharma, this Mr. Sahab, Manu Shankar, Mr. Sahab from MS Mishra and Associates.
Thank you, Mr. Gupta.
He's from?
MS Mishra and Associates.
Now, the subject of banking as such is a very complex subject. It cannot be summarized in terms of one or two acts. Let's be very clear on that. Now, the relation between financial economics, the relation between real economics, this still baffles all the economists globally. They are still to come to terms about what we mean, what is the exact correlation between the actual values and utilities which are used in the real economics and what are the notions prevalent in financial economics. Now, as I understand, financial economics one of the basic concerns is facilitation, making availability of capital when, as and when required. Therefore, when capital is made available as and when required by someone who has foregone use of that capital or that money for the time, he needs to be compensated. Therefore, the notion of paying interest and other things have arisen. Now, interest and usury are two terms. They are not the same thing. So, before we proceed any further about what are the rate of returns and why money and banking needs to pay attention to interest and how to recover assets, non-performing assets, etc., we need to state clearly what is the exact difference between interest and usury. Normally, it is said that if you use a very exorbitant rate of interest, say above 6%,